Okay, this is People of the State of Michigan versus Jeremiah Jackson, docket number 20-696FH. And Mr. Jackson, you are here today on allegations that you are in violation of probation. It's alleged that since the date of March 15th of this year, you've been in contact with Tashana Hawkins in violation of the condition of probation of no contact. Do you understand the allegation against you?
Yes, Your Honor.
If it's proven true, it could subject you to a maximum penalty of up to 4 years in prison based on your original conviction. You have the right to be represented by an attorney. You are represented by Mr. Austin. You also have the right to a contested hearing where you could appear by yourself or through your attorney. You could hear the evidence presented against you. You could cross-examine witnesses, and you could present your own evidence. And Mr. Austin, can you tell me how we'll proceed on this?
Yes, Your Honor. It's my understanding Mr. Jackson will be admitting to the violation.
Is that right, Mr. Jackson?
Yes.
Okay, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Jackson, as I told you, you have the right to a contested hearing. If you plead guilty, you won't have a contested hearing, and you'll give up the rights that go along with it. That includes the right to have the allegation proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes.
Has anyone made any promises to get you to plead guilty?
No, Your Honor.
Has anyone used any threats or other kinds of pressure?
No, Your Honor.
Are you pleading guilty because you believe you did violate probation?
Yes, Your Honor.
Okay, tell me about that. What did you do?
Me and the victim, we was having contact. After you said it was no contact, I could honestly say I was being stupid. I was being dumb for sure. Being hard-headed, which I shouldn't have, when I shouldn't have it, then I shouldn't have listened to you. And I just want to say I apologize to the courts. I apologize to my mother. I apologize to my family. I just hope, I'm just asking for another chance. Me and the victim is no longer together. We separated now. I'm going my own way. She's going her own way. So I would definitely not be having any more contact with the victim. The victim has also, sent my mother a text message disrespecting my mother. She even called up to board water and light and got my mother's lights cut off. And so it's just been like really a lot going on. And I understand I did violate. And I am in the wrong for that, and I do sincerely apologize, Your Honor, and I really do want to just ask for another chance. Because I've been working, I've been doing my cats. I'm just ready to move on in my life and just try to get to the.
You can tell me more about that in just one moment. I appreciate everything you said. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Jackson is found guilty of probation violation. Agent Allen, did you have a recommendation?
I do, Your Honor. Based on the fact that both I know your office as well as myself spoke to Mr. Jackson and Ms. Hawkins after his sentence, advised that at no time was he to have contact with her. Since that time, according to the information I received from the Ingham County Jail, there's been over 400 contacts in writing and in-person visits. It even went on as late as last week when the victim, in this case, Ms. Hawkins, attempted to use a fraudulent name and an out-of-state phone number in an effort to circumvent the process that Ingham County uses to identify phone calls. I don't know what options would be available for Mr. Jackson in the community. I believe that if he were to be placed on probation, he is going to set himself up for a potential prison term because he'd run out of jail credit. And I firmly believe that he would be violating his tether and violating the conditions. I think what is best for Mr. Jackson and everyone is that he serve 12 months at the Ingham County Jail, complete his sentence, terminate his probation, and then if he wishes to move on, I apologize, Your Honor. If he wishes to move on with his life or to have contact with this victim, he can do so without court supervision or probation department.
All right, thank you. I'm going to ask for input if there is any from the prosecutor. I don't usually do that on probation violations, but this was such a recent sentencing and it involves the victim that maybe they have information or anything else to say.
Your Honor, I would agree with Mr. Allen on this. I know the victim did want the no contact order lifted. She did contact, I think, your office. She's repeatedly said that I think there was a child involved, but at the same time, we dealt with that and we told the defendant, we're not lifting it. This is not going to happen. And I guess I agree. I'm concerned that if he is out on probation, he's not going to be able to abide by that. So Ms. Hawkins was aware that we're not going to lift it and that this court has declined to lift it and the concerns about what would happen if it was lifted. So I would think that that recommendation makes sense to me.
All right, thank you. Mr. Austin, I'll hear from you.
Yes, Your Honor, thank you. I know that Mr. Jackson has gotten off to a really bad start here. But what I can say in speaking with Mr. Jackson, I mean, he appeared to be very genuinely contrite when I spoke with him, and that it was impressed upon him, and I think he gets it how serious these court orders are, and that he's going to have to abide by them if the court is to allow him to continue on probation. And he has expressed that to me, which he has already, I believe, expressed to the court and probably will again. He's been working as a trustee while he's in the jail, so he's putting his time there to good use, working on getting housing lined up and getting a job lined up. His brother works at a factory and believes that he can get him employment once he is released from the jail. And essentially what Mr. Jackson is asking for is another chance to prove himself on probation. So I would ask the court to impose some type of sanction that would allow him to continue on probation. If the court does not feel that that is appropriate, then I would ask for a sentence towards the lower end of the guideline range, not to exceed 6 months. Thank you.
Thank you. And now your turn, Mr. Jackson. What else did you want to say?
I just want to say I have learned my lesson. Like I said, me and the victim is no longer together. We will not be having any more contact. I don't want anything to do with her anymore. I'm going my separate ways. She's going her separate ways. I'm just trying to get out, do what I got to do on probation, and complete probation. Be there for my dad because my dad is in the hospital. He was really sick, and I'm his only child, and I don't know how much longer he will be here. And I just want to be in his life and be there for him. And I just want to ask for another chance and just say I really do apologize.
All right, thank you. And Agent Allen, what are the credit days so far?
Your Honor, I just looked. He has, as of today, it looks like he has 257 days credit.
Okay, thank you. Okay, well, I must say, Mr. Jackson, you are so polite and respectful and appropriate in court, and you sound so sincere, and I could easily accept all of that, but the level of the violation in this case is just outrageous. And, I think I was really, really clear when I sentenced you a mere 2 months ago that you were not to have contact with her. I know she wanted it, but that's not the point. She's not on probation. You are. I could count on one hand, if that, the number of times I've had a probationer violate before they even got out of jail on their initial sentence. You've not only managed to do that, but you've done it in a real bang-up way with all these contacts with the victim. So while I would like very much to trust you, and I would like very much to take your sincere apologies and believe that this will be okay, I can't do that any longer. So I'm going to revoke probation. I would note that this is not a technical violation. I'm going to revoke probation and sentence you to 12 months in jail. You get credit for 257 days already served and no sheriff's tether release. Mr. Jackson, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. We will send you the appellate rights form that tells more about that and that you used to do that. You should just be aware that the time starts running from today. Do you have any questions, Mr. Jackson, before we go?
No, Your Honor. I just want to add, you said how many days credited I have again?
You've got 257 days credit.
Okay.
All right, good luck to you,
Yep.
Mr. Jackson. You can tell them at the jail you're all done.
Okay, thank you.
You're welcome.